Okay, so good afternoon. Thank you for joining our webinar on employee ownership trusts. Hopefully that is why you are all here. If not, you're in the wrong place. My name is Esther. I'm a partner at Kingston and we are commercial partners of the PRCA. I regularly host sessions for them, chair their FD forum and present their annual benchmarking results. Some of you may well know us already, but for those of you that don't, we are leading accountants and advisors to the media industry, working with clients right across marketing services, film, TV, theatre and media tech sectors. And we work with hundreds of clients, really ranging right from startups through to independent agencies, multinational groups, and even some AIM-listed companies as well. So it really is about the sector rather than about the size of the client. We're part of Kingston, which is a top 15 audit, tax and advisory firm. And that in turn is part of an international network called More Global, with presence in over 100 countries. So we're very well positioned to support our clients as they increasingly go international. So as I said, today we're going to be talking about employee ownership trusts and why they're becoming so popular. But before we delve into some of the detail, and you'll be pleased to know that we're not going to do a PowerPoint presentation. I think everyone's sick of PowerPoint presentations, so we're going to do this as a chaired Q&A, which we found actually works really, really well. But before we go into the detail, I'm just going to give you just a broad overview of what selling to an EOT means, just to make sure everyone is leveled out on the basics here. So the concept is relatively simple. The owners of the company sell a majority stake in the company to an employee ownership trust at an agreed price, which needs to be at a fair market value. And then the consideration is due to the sellers by the trust and is generally paid over time, often self-funded by future profits of the business. The capital gain that the sellers make on the proceeds is free from capital gains tax, clearly a very attractive proposition, particularly given that capital gains tax rates may well go up next year. And your company is now majority owned for the benefit of the employees, which obviously helps to generate goodwill and increases their engagement with the success of the company going forward. And for some, this is quite an attractive proposition and a good alternative, perhaps to selling to a trade buyer, and perhaps a good alternative to trying to facilitate a management buyout. And we're doing lots and lots of EOTs for clients at the moment. They're very, very popular and becoming increasingly popular, and advising on the tax, the accounting, the HR, the legal, and also doing the valuation piece as well. And obviously, you know, that makes for a very joined up process because we can advise on all aspects of the deal and nothing falls through the gaps. But as I said, obviously there's much more detail to it all than this. So we put a panel of experts together to talk us through. We have Mike Hayes, one of our tax partners, Andrew Bloom, one of our legal partners, and Amy Cretten, who is the director of our HR consultancy. So there will be time for some questions at the end, but obviously if you've got questions that you'd like to raise as we go along, then please do put them into the Q&A function, because it's much easier to track them through the Q&A function. So we're going to start with Mike, and I think one of the questions I often get from people is, this all sounds a bit too good to be true, selling for 0% capital gains tax, but there is a little bit more to it in the qualifying conditions, isn't there, Mike?
Yes, there is. I trust you can hear me, by the way, because my AirPods have just run out. Oh, good. Yes, there is more to it. I mean, there are a whole number of conditions that you need to sort of meet, but we'll just go through the main ones for now. I mean, firstly, it's got to be an arm's length type sale, so you've got to actually have a proper valuation to actually arrive at the sales price. One of the key conditions is that at all times the trust must control the company, so it must own more than half of the shares in the company. And that is a very wide test, so it's not just owning a number of shares or controlling a number of votes, it's also being entitled to more than half the dividends or more than half the assets on a winding up. So it's a very comprehensive control test. And what that does mean is that if you're selling to a trust, it's very dangerous to sell 51%, for example, because if something else happens, like you go and raise some money for shares, you'll get diluted below 50%. And what that means is that the capital gains tax relief that you've had gets clawed back. and if that clawback happens in the year of sale or the following year, it falls on the seller. If it happens after that period, it falls on the trust. So you have to be very careful about the proportion of shares that you sell.
What about the actual value that you sell for? Does it have to be a fixed amount, or can, similar to a trade sale, there be some element of earnout? And then if there is an earnout amount, does that qualify for the 0%?
The answer to that is yes. You can actually structure this in the same way as you might do a third-party sale. So it could be for a fixed price, albeit that some of that might get deferred until there's cash to pay for it. Or you could do it for an amount plus an earnout by reference to the next few years' profits. There's no reason why you can't do that. If you have an earnout, for reasons I won't go into, you need to be careful how you structure that if you want to have all your gain covered by the capital gains tax relief. And that requires some careful planning. But in principle, there's no reason why you can't have an earnout, and no reason why it won't work.
Yeah, great. And it's called an employee benefit trust. So what are the tangible benefits to the employees? What do they stand to gain out of this?
Well, firstly, all employees have got to be amongst the class of beneficiaries. So that's the first thing, and that includes employees wherever they are. So if you're a UK company with an overseas subsidiary, say in America, all the US employees have got to benefit. In terms of the benefits that can be provided, I mean, the main one is that bonus payments can be made, and up to £3,600 of those bonus payments are going to be made free of tax, but not free of national insurance. Now, not normally the payments are actually made by the company, not by the trust. So the company actually makes the payments. As I say, £3,600 would be free of tax. Obviously, if you're making bonus payments to employees overseas, say in the USA, then those payments are likely to be fully taxable, because obviously the exemption doesn't apply for US tax purposes.
And how are these benefits shared by the employees? Can you sort of dish it out however you want, or does there have to be some structure to that?
Well, you can't dish it out however you want. Two main rules, really. One is everyone's got to benefit to some extent. So you've got to give everyone something. Something to a couple of exceptions, I'll say in a minute. And then there's an equality test. So basically, people are must benefit equally, but equal is not exactly equal. You've actually got to have them benefiting on the same basis. So you can weight payments according to things like length of service or salary, or a mixture of both. So you can actually weight it, you know, to actually benefit some people more than others on that sort of basis. You can exclude people for a probationary period of up to 12 months. So if you don't want new joiners to benefit immediately, you can exclude them, and you can also withhold payments if somebody's going through, say, a disciplinary, and until the disciplinary is resolved one way or another. But that's sort of how it works. But basically, everyone's got to participate on the same basis.
I know in some of the EOT structures that we've done already, this sort of relatively flat structure is a bit of a cause of concern should there be a secondary event, and should the EOT go on to do a trade sale, where they might want some of the key senior management team actually to benefit more than some of the more junior employees. And that there are ways that we can get around this, aren't there, Mike, and make it more attractive?
Well, we can, the way you actually distribute your bonus can actually change over time, as long as you meet the requirements of the legislation. So you may have one method of distributing bonuses out of profits as you go along, but if perhaps there's a capital event and the trust is sitting on a large pile of cash, there is no reason why that cash cannot be distributed in another way, as long as it meets the requirements. So you might say, for example, you've weighted your ongoing bonuses according to salaries, but you might decide actually when it comes to a sale, you want to actually give people at the bottom end the bigger shares. So you might divide it into two, and half of it's divided by reference to salaries, and then the other half is shared equally. So you can do something different on that occasion if that's what the trustees think is the best thing to do.
And what about layering on things like EMI schemes?
There is no reason why you cannot run an EMI scheme alongside a trust, and that's something that we've done in a number of cases. So if you've got one or two key executives you would like to provide some additional incentives to, then there's no reason why an EMI option cannot run alongside it. Yeah. The only proviso is the EMI option cannot be over shares owned by the trust. So if the trust owns 100% of the company and you're granting a new chief executive officer an option to over 3% of the shares, it would have to be over new shares, because the trust has to benefit everyone, and obviously giving somebody some shares, one person, is discretionary, and that's not permitted.
Yeah. I mean, quite a few of the OTs we've done, people have gone on to implement EMI schemes. I think it is a really good way of marrying the two incentive schemes together. And also there's lots of detail that needs to be decided on in terms of actually implementing the OT, but one of the ones that has a particular tax angle is whether or not you have onshore or offshore trustees. There's quite a big tax difference there, isn't there, Mike, in the tax analysis?
Yes, there is. I mean, one of the unfortunate things about an EOT is that if you have onshore trustees and there is a sale to a third party down the road, by having a UK resident trust, the trustees pay capital gains tax at whatever the rate is at the time. And then once they distribute the cash out to the beneficiaries, then subject to the 3,600 exemption, that cash is going to be liable to income tax and national insurance. So you end up with a really big loss of tax. One of the benefits of using an offshore trust is, if you do it properly, is that you avoid the capital gains tax on a sale. Still means you're liable to the income tax, but at the end of the day, and the national insurance, but at the end of the day, the employees get more out of it. We've had, so far, I think the choice between UK and offshore trusts, it's been about 50-50 clients. The Inland Revenue appear to accept the use of offshore trusts. We get tax clearance in advance for all our disposals to trusts, and they have accepted that with offshore trustees without any issue.
Yeah, it's a bit of a trade-off, isn't it, between the tax saving and how the sort of the control and influence of the directors works, and we'll come on to that in a second with Andrew. But before we move on to Andrew, there is a question coming around: are there any issues with minority external shareholders, for example 10% shareholders? I'm assuming the question means in relation, but Paul, correct me if I'm wrong, who's asked the question in terms of the tax analysis on the sales of the EOT. So do you want to pick that one up, Mike?
So I'm just reading the question. Are there any issues with minority external? Well, a minority shareholder can actually sell their shares to the EOT. It doesn't have to be just the controlling shareholder. And obviously, if the intention is to sell the whole company, an external shareholder can sell their shares. I don't think there's any issue with that. That's not a problem. Obviously, if that shareholder is not an employee or an officer of the company, they can't be a beneficiary of the trust. And one of the things I should have mentioned, probably going on to that, is that if you are or have been the owner of 5% or more of the shares at any time in the last 10 years, you can't actually take any benefit from the trust. So that's one quite important thing just to bear in mind. So if you do have some employee shareholders who own sort of 5% or more of the shares, they won't be able to benefit from the trust, although they can actually sell to the trust. But
we're learning a bit more here. The 10% shareholder is an ex-employee who is awkward. I guess that depends on the drag and tag rights, doesn't it, Andrew, in the constitutional documents?
Absolutely, and also whether there's any specific provisions in a shareholders agreement. So that's Paul, that's something that we can certainly look at on a specific basis. But yeah, it's either a problem or it's solvable depending on the detail in your documents.
But I guess they might be persuaded by the 0% tax, which presumably might they still get even though they're not an employee. The 10%, the 0% tax, does that apply to all shareholders, or is there some rules around who might get the 0% and who doesn't?
So is that a question for me?
Oh, it was a question for you, yes. Does everyone get their 0% tax on the sale to EOT, regardless of whether they're an employee or not?
That's right. Yes, it's any shareholder can actually get the
yeah. It's more the rules around how you benefit from the trust going forward if you're not not an employee, isn't it? So going in, it doesn't matter. Once you're in, you can only benefit if you're an employee, and then only, as Mike said, if you haven't had 5% holding in the EOT previously. Okay, so Andrew, bring you in now to tell us a little bit more about the actual ownership structure that the company would actually end up with if they were to sell to an EOT. And I think you've got a little slide that you're going to use. Just the one. We've allowed one slide.
This will not be death by PowerPoint, and it will just be for a short period only. Otherwise, I know someone will cut my access to the webinar off. So I'll just share screen very quickly, because it's just sometimes helpful to see a diagram to show this. So if you think about your company at the moment, that's probably owned by a group of founders or shareholders, and that's what we've got in the middle of this chart at the moment. Now the shares in the company, at least 51% of them will be sold to a trust company, which will act as trustee of the employee ownership trust. So if you can see my mouse, you're kind of working around this picture with me in a clockwise fashion. And so it's the trust company that acts as the trustee of the employee ownership trust. There will be some employees who might have shares if you were to do something like an EMI, as Esther mentioned. And as one of the participants mentioned, you might also have some existing shareholders who may have sold some shares or may have retained some shares. So that will be the ownership structure. As Esther said at the start, one of the things that's really important about all of this is making sure that the company is run for the benefit of the employees. And with the trust company, owning the shares on their behalf, it also makes sense for the directors of the trust company, who act as trustees, to take into account the views of employees. And a very common way of doing that, so as to have a forum for the employees to express their views and communicate them to the trust company, would be what's people call an employee council. But it doesn't have to be called that. It can be given other names as well. Some companies have their employee council just for communication and consultation. Others give their council the right to appoint directors, so trustees to the trustee company, or employee directors to the actual trading company. But those elements aren't essential. It's basically what's right for the culture of this actual company. But that's the basic ownership structure, and you'll be relieved to know I'll stop screen sharing now.
Thanks, Andrew. So, I mean, one of the questions I get asked quite a lot is to what degree do the owners give up control when they sell to the OT? Now, I think one has to accept that there is a degree of loss of control, because you are selling your shares, but to what degree do you actually lose control, and what sort of control can you retain?
Well, I think there's two sides to it. That there does need to be a loss of control, because it's an essential requirement of company law that directors act in the best interests of the company's shareholders. And when an EOT sales happen, more than 51% has been sold to a trust to benefit the employees. So all of a sudden, whereas company directors consider employees every day in all sorts of scenarios, now that consideration becomes a far more important requirement. However, that's not the end of the story. In many EOT transactions, there will be a sale price, as Esther said, as a set of fair market value, but it won't all be paid on day one. Some of it will be paid maybe up front, and some will be paid in instalments. So what we often see is, while those instalments are being paid off, often over a number of years, the founders should have certain veto rights. So a right to approve or disapprove of certain key transactions that could affect a company. So, for example, pay rises above a certain level, hiring new employees with a salary above a certain amount, maybe buying a new office or starting a new business venture, all sorts of risky things that could harm the company's ability to pay off the price for the sale of the shares. So it's, yes, there is a change of control, but yes, there's some protections that can be built in for the founders.
Thank you. One of the other concerns that I think lots of people who are considering this have is how certain they can be as to actually getting paid their proceeds, given that the trust is reliant on these gifts and these discretionary gifts from the company. I mean, obviously, if the sale is self-funded, then it does depend to a large extent on how profitable the company is going forward. But to what degree can protection be built in that those proceeds will eventually flow through to the original sellers?
Well, you're right, Esther. A key part of the tax legislation is that the payments that end up getting made by the company, by the trading company to the trust company, are paid to it as discretionary gifts, which the trust company would then use to pay off the deferred consideration. But if that doesn't happen, then there can be risks to the founders as to whether or not that would be paid. Most people think that those risks can be managed by various protections that we put into the documents. Some advisors I know talk about putting in some sort of a parent company guarantee, so that the trading company guarantees the payment. We don't advise that, and in fact advise against that, because there's some potentially strong arguments that could cause the tax rules to be breached, so you wouldn't actually end up with the OT tax benefits anyway. So we can put protections in place, but there are some risks.
Okay. And in terms of, we sort of alluded to earlier, there's a choice as to whether we have an onshore or offshore trust, and obviously that has quite a big difference on the tax analysis, but it does affect how the chain of command works. Could you just tell us a bit more about the difference between onshore and an offshore trust?
Very much so. So if you have an offshore trust company, that would generally be a professional trustee company, often in the Channel Islands, and one of their businesses is to act as trustees of all different types of trusts. That they'll come from a starting point that they know nothing about your business or the culture or the staff or your clients or customers, and they've got a learning curve. Often they'll want to consult with an employee council or employees to make sure they're doing their jobs as trustees, but you do have that degree of extra formality in terms of having external people involved in making key decisions for the business. On the other hand, with an onshore trustee, it would generally be a new company that we would form as a subsidiary of your main trading company, and you've got a much wider choice as to who you put on the board of that company. So effectively, you can keep it within your corporate family, people who are connected with the company. Some people often bring in an external director to that trust company board, but then you've only got one external director, often with a bunch of in-house people. So it makes the decision-making process much easier.
And then one of the other areas we talk quite a lot about is who will actually be on the boards of these various different companies. And there isn't really a fixed rule around that, is there? But what flexibility do people have with who's on the trading company board, who's on the trust company board, etc.?
Absolutely. We generally recommend not having identical makeup on both company boards, because people have to think about decisions almost wearing a different hat, whether you're making decisions just for the business on the trading company board or more for the employees as a trustee or on that company board. So I think as a general rule of thumb, people more directly involved in operational side of the business on the trading company board, maybe having an external or an employee representative on the trust company board to just to give up an extra element of guidance from the employee's perspective. But equally, some people do kind of give employees even greater say by having employee reps directly elected to both boards. But as I said, it's horses for courses and what's best good for your company and your culture. Yeah.
Yeah, and then we've heard a lot about we've mentioned employee councils today. I mean, what does that, a lot of people, that would be a new sort of concept to them completely. What does that actually mean to have an employee council? Do you have to have an employee council, and what is its role?
Absolutely, you don't have to have one. We generally recommend having one. You don't even have to call it an employee council. We call it an employee forum or anything like that. So it's not provided for in the tax rules, but it seems to us that if you're having a trust set up to own a majority of the business for the benefit of employees, that you have some sort of way of communicating between the trustees and those employees. So we generally, when we've been helping clients set this up, we set up a set of rules related as to how the employee council operates, how people can become members of the council, what rights they have, as I said earlier, whether it's just to be consulted on decisions or whether to have actual veto rights and the power to appoint directors. And often companies will want a director from the main company board sitting there on the employee council, just to guide the conversation so that you don't necessarily get silly demands like everyone has to work, gets a 3-day week and a couple of bottles of champagne a week. Those sorts of things, just to keep the conversation in a way that's going to be helpful. But we can guide clients through all this process, and it's important also that the employees feel engaged, because a very important part of all of this isn't just an exit route for the founders, it's the benefits and really getting employees enthusiastic in employee ownership and feeling that they're involved and have a say in the running of the company, not just that they're effectively owners, albeit through a trust.
Brilliant, thank you. I had another question come in. What happens if an employee leaves the company after investing? Are they locked in? I don't know who wants to take this, but I guess I'd sort of make the point that the employees haven't necessarily invested as such. I mean, they haven't had to pay for these shares. It's that the owners have sold their shares to the trust, and the employees are then beneficiaries of this trust. The employees don't have to find any cash to invest. But I mean, Andrew, do you want to pick up the locked-in point?
Yeah, sure. They're not locked in at all. It's frankly one of the benefits is to keep loyalty and to keep employees. So if they do leave, they effectively lose their EOT benefits, but there's no loss to them because, as you said, Esther, they haven't invested.
No.
One exception that we do often put in is that, let's say, unfortunately, an employee had died or become incapacitated or something like that, and then the company was sold and there was going to be a big upside, within a couple of months after it. The transaction might even be negotiated while that unfortunate event happens. We can actually extend the period within which their beneficiaries could participate. So they could actually have some benefit on that side, but that's obviously, thankfully, quite a rare scenario.
Mm. Do you want to add anything to that on the tax side, Mike, or has Andrew covered it all?
Right. I mean, they are tied in. I mean, the question might be asking is, should they still get paid out in full if they leave the company after having sort of sold?
Yeah.
And that becomes an issue, and it's sometimes an issue on sales to third parties. I mean, it might be possible if somebody leaves the company after selling their shares to actually have some form of restriction into the amount that they get paid, particularly if their presence is vital in, significant in terms of generating the profit that's going to pay them out. So that if they've gone, there's going to be less profit to actually fund the whole transaction. It may be possible to have some form of restriction in their price to reflect that, but you have to be very, very careful about how you structure that. And it's the sort of thing, to be on the safe side, I'd like to steer away from, but there is some possibility.
And you're talking there, aren't you, Mike, about the initial sale of the current owners to the employee ownership trust, and looking at whether they might lose out on some of the consideration that's paid in year 2, 3, 4. Because generally, the transactions that we're seeing, actually the payout periods are quite long, because generally they are self-funded. It's fairly rare that they are, bank financed or something like that. They tend to be funded out of future profits of the company. So the payout period could be, could be 7 years or something. So if somebody leaves in year 2, Mike, you're saying on the face of it, it's much simpler if they just continue to have rights to the remaining consideration, but there are things you can put in place to restrict it or make it less attractive to leave. We haven't got any, we've still got some more questions of our own to cover. We haven't had that. There's only one person asking questions at the moment, so please, everyone else, do pitch in if you've got questions to ask, and we will we'll pick them up as we go through. But Amy, just bringing you in now on the HR side. Amy's the director of our HR advisory business. So, I mean, business owners, it's sort of slightly changing the flavour of the relationship between the business owners and the company, isn't it? They're sort of now just going to be employees rather than owners. So is there anything specific that we need to think about in terms of their employment contracts?
Yeah, it can be really worrying, can't it? If they've been owning the business for a number of years and then suddenly they're becoming an employee, obviously they want to be protected. They don't want to get a few months post-sale and then find out that they're no longer employed, or the employees that are now shareholders make a decision to oust them. But equally, the employees themselves as well, they don't want to get a few months post-transfer and then the previous business owner decides, I want to go to the Mediterranean, I want to sail away on my yacht. They don't want to lose that wealth of knowledge and that experience that they had. So we can put some stuff in the contract that just basically protects them. It protects the employment so that it can't come to an end earlier than mutually agreed. Either that's a date in the future that has already been set, or it's just by mutual agreement. So there are protections that can be put in place, and it just protects all parties then from having the rug pulled out from under them, basically.
And what about protecting the actual investment of the business owner? What things can you sort of put in place to motivate the employees to really care about the sort of the ongoing financial performance of the company?
I always talk about incentives. More often than not, they're financial, but they don't have to be. If employees are being incentivized to work for the company and to work towards the company's objectives, to bring in more income, to generate more revenue, to provide a good service, depending on what their role is, they're more likely to if they're incentivized. And if they're incentivized, they're more likely to be engaged. And we know that an engaged workforce does provide a better experience for the clients and for the customers, and they do more for the company, and they do want to meet their own objectives and then obviously achieve team objectives and company objectives. It's like a domino effect, basically. But we do talk around incentives a lot. I mean, obviously there's that tax-free bonus scheme, but we are quite limited as to what we can do with it. But with bonus schemes, essentially the options are limitless. There's so much you can do. I always suggest a move away from a really complicated one, but sometimes they can get quite complex. But yeah, there's lots you can do, and really incentivizing your staff, I think, can go a really long way. But like I said, it doesn't have to be financial, because not everyone, money doesn't speak to everyone. So it's about knowing your staff as well, and knowing what exactly is going to incentivize them and motivate them.
Yeah, absolutely. I mean, certainly I think the current flavour, it's work-life balance that seems to motivate people just as much as the hard cash, and hard cash has almost become a hygiene factor.
Yeah, absolutely.
Plenty of other interesting ways that you can motivate people. And I mean, some people might be concerned that becoming an EOT might just make it much more difficult to make management decisions within the company. I mean, is this the case, and what advice would you give to them?
We've seen it before, actually. A few years ago, we were advising on an EOT, and the employees, they hadn't been educated on what it was and what it meant, and so it all went through, and then the employees thought, great, we own the business, we can do what we want, and it became really disruptive, and it caused a lot of issues. But essentially, the people managers are still people managers. They still monitor performance. Everything still exists. You're still being line managed as an employee. So all those management decisions happen. They don't get taken away. And I think it's really important to, like I said at the beginning, educate the employees about what it is and what the structure is going forward and what it means. But also the managers as well, because they might well shy away from those kind of decisions. And actually they can still carry on as they always would have done. And it's about getting buy-in. I think with something like this, lots of people won't understand it. And so it's really about talking to people. The communication is absolutely key right from the beginning, and getting that buy-in, because it's as much about change management as it is anything else. And we know that 75% of the working population, for example, have a personality type that doesn't like change. And this will be a change, whether or not it's the line management structure changes or not, essentially there is a change in their mindset. And you hope there would be, in some sense, because you want them to have that kind of ownership mentality and really care about the business and think about what they're doing in their day-to-day role. How's that impacting the long term? So you do want them to have a change of mentality, but ultimately, no, line management decisions, they don't change. People can still be managed, and they should still be managed just as they were.
And is there anything else from a people point of view that you would advise a business owner to sort of properly consider before selling to an EOT?
I don't think it's any different to if they were selling to another company, to be honest. I think it's just about getting your structure in place. So make sure when you look at your workforce, make sure that you're confident that you've got the right employees in the right positions doing the right roles, and that if you're aware of your key risks, who are the people that if they were to leave would be a big problem for the company? Is there a succession plan? Do you have contingencies in place? Because obviously you are selling to an EOT, and you want to make sure that this business is still going to survive and still going to do really, really well with you not owning it. And I think having your structure in place and getting all of your HR eggs in a row, as boring as it sounds, will really help you, and making sure that you've got the policies and everything in place to protect the business. I think that's really important.
That's great. Thank you, Amy. So we have had a couple of questions come in. Are there any rules or recommendations around the size of business that might be well suited to selling to an EOT, and what impact does the number of employees actually have on how many employee reps you would need to have? Who wants to take this one? It could either be Mike or Andrew, I suppose. Being a tax angle as well as a legal.
I'll have a go for a start, and then Andrew can chip in. I mean, in terms of size, there are no size limits. So technically, it can be any size of company. I mean, the largest one that I've been involved in was for a valuation of £60-odd million. So not a massive company, but a sizable and profitable company, and it had quite a few employees. But there's no size limitation at all. And if you look in the press about companies that are sold to EOTs like Richard Sounds and other companies, I mean, they're quite big. So there are no size limits at all. I mean, if you do sell to an EOT and you do go through the employee council route, I mean, clearly what you've actually got to do is set up a structure that actually makes the numbers manageable. So, you know, if you have a situation where you have two board representatives, for example, or two trustee representatives for employees for a company with 50 employees, it doesn't mean you have 8 because you've got 200 employees. You know, you don't simply scale up. So you've actually got to come up with what's a manageable arrangement. So simple as that, really, I think.
Yeah, I agree with that. And it's you know, I think a lot of the I don't think I've seen an employee council with less than 3 members. Some would have more. If you had a business that was split between lots of different offices and lots of different sites, or different business divisions where people are likely to have a different perspective depending on which business division they're in, that might influence how many, just so that everyone feels that they've got proper representation and having a say. But there's no hard and fast rule.
So I've had another question, or rather comment come in. It's an interesting one, actually. So somebody who's sort of struggling to see really what's in it for the directors and owners. Why on earth would they sell to an employee ownership trust when they don't get their cash straight away, and the employees don't even have to pay anything for their shares? Again, I suppose that's a double-pronged attack from Andrew and Mike. And I guess, Mike, when you answer your bit, it might just be worth, actually, given that we have got time, doing a bit of crystal ball gazing on what might happen to CGT in the next budget.
Yeah, sure. I mean, I think the point there is EOTs are either used in situations where a third-party sale or a management buyout is not possible. So it's an alternative structure. And some businesses, you know, we've had one where they couldn't actually find a third-party buyer. So EOT became the only sort of way forward. Similarly, you know, you may want to encourage the management to actually have a management buyout, but if if the management don't actually have the inclination or the financial wherewithal to sort of put some money into that, then your options are becoming more limited. So why would you do it? Well, I think the capital gains tax saving, I would have thought, was a significant incentive, and we face the prospects, perhaps in the November budget, of an increase in capital gains tax being announced. So I think that is quite important to just bear in mind, is that, you know, capital gains tax this time next year could be at 40% or something like that. So it certainly makes it more attractive. The other point I would mention is, for many of our clients, they do see employee ownership as the way forward with their business. You know, this is not simply about the tax break, although I think they all quite like the tax break. They do actually want to, they've built the business over a number of years. They do want the employees to eventually take it over and run it. So it's a sort of philosophical approach, really. They see that as the future of the business. So people do it for all sorts of reasons, but I hope that helps.
Yeah, thanks, Mike. Andrew, did you want to add anything to that?
No, I agree with Mike's comments. It's about we've seen some of our clients being incredibly proud that they're able to pass on the business to their employees, for whom they've got very great affection for. They may be close, the founders may be close to retirement age and otherwise worrying about the future of the business, but feel it's in good hands if it goes to the employees. And want the business to go on and thrive and continue to grow and succeed under different leadership and ownership, but rather than being sold out to a trade buyer who may have a very different culture and very different kind of long-term aims for the business. So a lot of it is about the human side, as well as the economic and tax benefits for the founders.
Yeah, I mean, I'd add to that from a sort of a corporate finance and valuation point of view, that if you're selling to a trade buyer, you don't get all the cash up front either. You know, you might get 40% of what you might expect to get overall as an upfront down payment, and then the other 60% will be paid as an earn-out, maybe over 2 or 3 years and subject to future performance. So in that situation, there is still an element of risk as to whether you get your future payments or not. And of course, whether you get your future payments in an earn-out depends on the performance of the business, which largely is down to how motivated and hard all the employees are working to generate that earn-out. So of course, if you're selling to an employee ownership trust, you've got more influence probably over the direction of the business, and all the employees are more motivated to work hard and push the business forward because they do stand to ultimately gain from it. So, and another big attraction, I think, is where there's a lot of surplus cash on the balance sheet at the moment. So some businesses, you know, if you haven't been taking out dividends, can be sitting on quite large pots of cash. And of course, taking out as a dividend is very expensive. You know, it could be top rate of 47% tax once you've got your NI in there. But selling it to an EOT enables you to remove that chunk of cash immediately. So that could be your immediate down payment, and that comes out tax-free, which is obviously a huge difference between paying 47% on it as a dividend. So I think there are, like Andrew and Mike said, there are lots of different reasons as to why people do this. For some people, you know, fair play, it's a primarily a tax motivated reason, because people are terrified that CGT is going to go up next year. And actually the idea of selling to an EOT, I mean, even if you're going to get a little bit less, you've got to get quite a bit less for it to compensate for a potentially 40% tax charge. And others are doing it primarily for the sort of employment motivational aspects. And obviously it improves your ESG credits as well. And that sort of does seem to be the direction of travel that the world is moving in. So a comment back coming. Are we saying that the owner is effectively gifting the majority of the equity to the trust? Well, they're selling it. They're selling it to the trust. So if your business is worth 10 million quid and you're selling half of it to the trust owes you, you know, 5 million quid. So you're not gifting it. You are selling it to the trust. The trust then owes you those sales proceeds, and those sales proceeds are funded by the future profits of the company. The company then makes gifts to the trust, and then the trust settles its obligations to the seller. So you're not gifting it to the trust, you are selling it to the trust. Don't know whether you wanted to add anything on that point, Andrew and Mike.
No, I agree with that, and it's you know, you're getting you could give it away, and then you wouldn't receive the you wouldn't be entitled to the £5 million in the example that Esther gave. So it is different from that, but obviously it may take a while for the money to come through, depending on how you structure the sale proceeds.
Yeah. Another question come in: how does the transition normally go? Does the previous owner usually stay in a senior position such as MD, and how is this decided? I think that's probably one for you, Andrew, isn't it?
In all the ones that we've worked on, the founder has absolutely stayed on, and it's crucial that they do, because they need to continue to be engaged in driving the business forward, together with, you know, maybe an up and coming management team, and effectively the founder can dictate what they want the arrangement to be. And we often, as part of the documents that we prepare, many founders have never even thought of even having an employment contract, but when they're no longer the majority shareholder, frankly, that they need one, and part of what Amy and her team do is put one in place just to clarify in writing what the founder's role will be, what their payment, how much they're going to get paid, and what their rights are going to be, and all the rest of it. So absolutely, they usually stay on board. But it's not essential. If they wanted to go off and put their feet up, that's also fine as well.
Yeah, but you're right. I mean, you know, all the ones that I've been involved in, actually, you know, day 365 as a non-employee owned and day 1 of employee owned, nothing fundamentally changes overnight other than an awful lot of paperwork has been drafted and signed. The running of the business remains as it is. Yes, there might be an employee council in place either immediately or within a couple of months down the track, but generally speaking, the founders have continued to stay in the same position that they're in, other than obviously they've given up control of the business, but the actual day-to-day running of the business, the owners are still running it.
Very much so.
And making those day-to-day decisions. So I think that sort of comes on to this point here about the next person saying, you know, you lose your agency founder, or, you know, well, you don't necessarily lose the agency founder. Often those people are staying on because they want to be part of the team that's moving forward to generate the profits, so that the company. Oh, somebody's lost sound. Has everybody lost sound? Or is it just Mike?
No, I can still hear. I think
it's just you, Mike. So yeah, more often than not, the founders, the current CEO, management team will stay in place. It's not like they disappear.
If the company stops making profits, the founder isn't going to get paid out. Is effectively, you know, the bottom line, and it's very, very helpful for the founder to stay on board, keep driving the business to make sure that those profits are made for the benefit of everyone, for a healthy company.
Yes, exactly. And similarly, other than obviously the upfront portion you've had in a trade sale, similarly in a trade sale, you know, if the company isn't delivering profits going forward, you don't get paid your earn out. So, you know, there's risks in both, that you don't get paid the full amount of consideration that you would aspire to achieve. Yeah, a comment as well, you know, if agencies are doing this rather than a third-party sale, are they losing out on the business opportunities that a good M&A transaction would provide and enable it to thrive? Absolutely, I agree. You know, it's an alternative, and quite often some of the EOT transactions that we're doing is where there is not a viable third-party deal on the table, or not an attractive one that either isn't offering enough money. But obviously for some people, selling isn't just about generating money, it's about generating strategic opportunities, and a lot of sales that go on at the minute are about the strategic fit and not just about, you know, buying for scale. So it's an alternative, and you've got to weigh up the benefits of the employee ownership, the benefits of the tax saving, with the potential benefits that you would get from selling to a strategic buyer that has lots of other things to offer. Mike's disappeared. So we don't have any more questions, actually. Actually, we did have one right at the beginning, which was, what did we consider to be the essential ingredients to success? I think we've probably covered that in the round today, in terms of, you know, it is about pushing the business forward, and the employees being motivated along with the management team to push the business forward to generate the profits. Because unless that happens, then yes, the whole thing is going to be a bit of a flop and it's not going to be very successful.
And also communicating it to all the stakeholders.
Yeah.
So it's not just about us putting in place a whole load of beautifully drafted documents, but it's about communicating to the staff, having sessions to explain it, Q&As, making sure they feel involved and on board, and also that customers and suppliers are aware of what's happening, because that can be really, really positive for the company from that perspective, in terms of a really big social responsibility balance.
Yeah, I think you're right, Andrew. I think communication is absolutely vital, and I've seen it done well and I've seen it done badly. And given that part of the massive benefit of this is the opportunity to involve employees in ownership and motivate them by that, you've got to give some real good thought to how you're going to communicate it, at what point in the process you're going to communicate it, who's going to do it, by what method is it going to be, and get that absolutely right. Because if you don't, and I've seen it done badly, it's a real wasted opportunity and it falls a bit flat. Because don't forget that the people who you're communicating this to, you know, this is going to be a completely unfamiliar concept to them as well. It's not something they're ever going to have come across before. So you've got to really explain it in an easy to understand way. Amy, I don't know if you've got experience of seeing it done well and less well.
Yeah, we tend to take a two-stage approach. So you do the initial communication and give some information around what it is, and then you give them some time to digest it all and to raise their questions that they have, and then you have another kind of session. Depending on how big the company is, it might be that you have multiple sessions. If you've got less than 20 employees, it could be really good to get everyone together, but as soon as you get more than that, then people tend to not get an opportunity to ask their question, or people might be a bit nervous to ask the question in case they feel silly or something. So having some anonymous feedback from people or questions can be really helpful to make people feel comfortable when asking what they want to, and then responding to those and acknowledging either acknowledging what it is, what their comments are or their concerns are, or frustrations, or answering their questions. But having that two-stage approach has tended to work quite well in the past.
Yeah, brilliant. Okay, well, we are out of questions. I think we've probably said everything that we came to say today. So I'm going to give everyone 5 minutes back in their diary, which I think you'll all be grateful for. So thank you very much for joining us. Please do get in touch if you think an employee ownership trust is something that you might want to consider and explore further. And we're more than happy to have an exploratory chat with you. And just to say as well, we've got a page on our website dedicated to EOTs as well, which also has some extra information. So thank you very much for joining us, and I will say cheerio.